Amendment Bill 2020, insofar as it purports to predetermine the allocation of the proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its function of constituency delimitation is unconstitutional. Sichale J.A. dissenting. Number 13, the administrative procedures for the verification of signatures in support of the Constitution Amendment referendum made by the Independent Electoral Boundaries Commission are illegal, null and void, because they were made without quorum and in violation of Sections 5, 6, and 11 of the Statutory Instruments Act 2013. Sichale J.A. dissenting. And 15, a permanent injunction be and is hereby issued restraining the Independent Electoral and Boundaries Commission from undertaking any processes required under Article 257(4) and 5 in respect of the Constitution of Kenya Amendment Bill 2020. B. We hereby set aside the following declarations and orders of the High Court. 1. That President Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. 2. That Article 257(10) of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct questions, referendum questions to the people. Nambuye, Okwengu, and Kiage JJA descending. 3. The BBI Steering Committee established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette of 10th January 2020 is an unconstitutional and unlawful entity. And lastly, the cross appeals fail and are hereby dismissed. This being a public interest matter, the parties shall bear their own costs in these appeals and in the High Court. In conclusion, on behalf of the entire bench that heard these unprecedented appeals, I wish to sincerely thank all the parties and their respective advocates for the diligent manner in which they argue these appeals and for the industry that they put in the preparation of all the useful material that was availed to the court. The authorities were so voluminous that time did not permit us to peruse and cite as many as we would have wished to. I found the submissions by all the parties quite concise and well researched, and that is our task of preparing this judgment. I also wish to thank our legal researchers and secretarial staff for their immense help in the preparation of this judgment. And with that, we come to the end. We come to the end of our delivery of the judgment in these consolidated appeals. But there is one other, 307 of 2021. I don't know whether Mr. Charles Kanjama is here. Is Mr. Charles Kanjama here? Or is anyone holding his brief?
Yes, my lord. My name is Moki.
Yes. I
appear together with Mr. Kanjama. Mr. Kanjama appears virtually.
Can I request we have order, please? Unless you have to go, just sit down so that we finish. We want to finalize in the next 10 minutes, if not less. This is the judgment of the court, and it's a short one. The genesis of this appeal is that by an application dated 16th of March 2021, Mr. Charles Kanjama, hereinafter referred to as the appellant, sought to be joined as an interested party in Nairobi High Court petition number E282 of 2020, as consolidated with 7 other constitutional petitions, which sought to challenge various aspects of the Constitution of Kenya Amendment Bill 2020. The learned judges declined to admit the appellant to the proceedings. They stated that they would give their reasons for so declining in their judgment. On 13th of May 2021, the High Court delivered a lengthy judgment in respect of the consolidated petitions, but failed or inadvertently omitted to render the reasons for declining the appellant's application for joinder. On 26th of May 2021, the appellant filed a notice of appeal and subsequently a memorandum of appeal challenging the substantive findings of the High Court. The Independent Electoral and Boundaries Commission, the appellant in civil appeal number E291 of 2021, and the Attorney General, the appellant in civil appeal number E293 of 2021, filed applications seeking to strike out the appellant's notice of appeal dated 26 May 2021, as well as the appellant's memorandum of appeal dated 8th of June 2021. Their main argument was that the appellant, having not been joined as an interested party in the consolidated petitions and having not appealed against the ruling of the High Court, could not raise in his memorandum of appeal issues that he had intended to argue before the High Court. This court, Okwengo, Kiage, and Tuyot JJA, on 28th of June 2021, issued the following orders in respect of the 2 applications. 1, I will not read all those orders. The appellant subsequently filed a memorandum of appeal dated 30th of June 2021, which contains 7 grounds. However, only the following ground was in accordance with the ruling of this court, and it was this: the learned judges erred in law by failing to give reasons in the judgment in declining to admit the appellant in the High Court proceedings pursuant to the application for joinder dated 16th March 2021. When the appeal came out for hearing, the appellant wanted to argue all the 7 grounds of appeal, but the court directed that it could only hear the appellant within the confines of its ruling of 28th of June 2021. Accordingly, it is only the aforesaid ground that was argued. On that ground, the appellant argued that the learned judges erred in law by failing to give reasons in the judgment for declining to admit him in the High Court proceedings. This ground of appeal is unassailable. The record of appeal shows that shortly after a hearing the appellant's application, the learned judges stated, and I quote, "After due consideration of the rival arguments by the parties, the application by Kanjama to be enjoined as an interested party to the consolidated petitions is hereby declined. The court will give its reasons in its full judgment." End of quote. It is a requirement that under the civil procedure rules, judgment or ruling should contain a concise statement of the case, the points for determination, the decision, and the reasons for such a decision. The object of this requirement has been explained in several authorities. Although the learned judges had given the appellant the indication that the reasons for their ruling would be given in the judgment in the consolidated petitions, no such reasons were given.